Hello everyone and welcome to Compliance Kit's live webinar on compliance with the 60-day overpayment rule. Today's webinar will be presented by Jay Einstein. My name is Kishore and I will be the host today. So the session will be of 60 minutes, and if you have any questions during the session, you can just share it through chat window or you can raise your hand button on WebEx feature. So we will unmute your line. You can just talk to the speaker over the phone. So we'll start the session. Jay, I request you to please introduce yourself and start the session.
Okay, great. Thank you. Well, my name is Jay Einstein. I'm a healthcare lawyer that specializes in regulatory compliance and healthcare compliance programs, and here to talk to you today about compliance with the 60-day overpayment rule. This is an area that has developed over the last few years, and it's one that I think is always a source of potential compliance issues for any healthcare organization that's billing out a federal healthcare program payer. And so for that reason, I thought it'd be a good topic to go through just sort of the nuts and bolts with regards to the overpayment rule, as well as covering some of the logistics involved with a potential overpayment issue and reporting, and then also just talking about the structure from a regulatory standpoint about the 60-day overpayment rule. So with that, let's go ahead and get started. And the first thing I want to do is just kind of go through just some background, just specific to self-disclosures and taking a little bit of a 30,000-foot view level. And so, you know, something I think to keep sort of in the back of your mind as you're faced with any potential overpayment issue, really at the outset is just making sure that you do understand sort of where along the spectrum are you in terms of fraud and abuse. You know, for example, do you have a simple overpayment issue that would trigger the 60-day overpayment rule, which we're going to talk about a little bit more in detail today, or do you have something that is more indicative of potential fraud, or are you somewhere in the middle? Because some of the issues, you know, it may just be an incorrect claim that was submitted, which needs to be refunded to a MAC, or it could be something a little bit more serious. And of course, everything's going to be fact specific, and it's going to depend upon the facts. Sometimes you may know this up front, and sometimes you may not know it up front, and it may take a little bit of digging through your investigation to determine really what's going on. And so that's why I say this is just something to kind of keep in the back of your mind as you're going forward and investigating one of these potential issues. So when we're talking about reporting a potential overpayment, there are a number of different avenues for which you may be allowed or you may be required to report it. And so that's something also to keep in the back of your mind. Today we're going to talk more specifically about the first one, the returning money to a MAC through the 60-day overpayment rule. But just know you may have possibly a Medicaid overpayment issue, and that's going to trigger separate state Medicaid agency requirements related to disclosure. If you've got something along the lines that potentially is more fraudulent, then that would potentially trigger the OIG Self-Disclosure Protocol. There separately is a CMS or Medicare Self-Referral Disclosure Protocol, which is specific to potential Stark Law violations. So that's another avenue that you may possibly go down. And then there could potentially, just depending upon your facts and circumstances, it may just make the most sense to do a direct referral to the Department of Justice. And again, that's going to be fact specific, and I'll talk a little bit more what I mean by that as we go forward. But something at the outset I do want to make mention is the presentation today is not to be considered legal advice. You're going to hear me several times today as we kind of go through talking about the fact that when you're working on one of these overpayment issues, you really do want to make sure that you're working with the advice of your legal counsel, whether that's inside counsel or outside counsel, to assess any potential risk to the organization as you move forward. So What I want to do before we go back to the 60-day overpayment rules, I wanted to just kind of briefly touch on some of these other reporting avenues. So I had mentioned the OIG Self-Disclosure Protocol. It was issued back in 1998, and the principal purpose was really to provide guidance to healthcare providers that decide voluntarily to disclose any type of irregularity in their dealings with federal healthcare programs. And the OIG had intended to offer providers, whether it was individuals or entities, really a process to voluntarily identify, disclose, and resolve a potential violation of federal criminal law or civil law or administrative law, for which exclusion or liability under the civil monetary penalties law might potentially be authorized. And so in terms of what is eligible under the OIG Self-Disclosure Protocol, I just included some examples there. Billing for medically unnecessary services, E&M upcoding, duplicate billing, altering records, any type of situation factually where you have potential inducement for referrals of federal healthcare program patients in violation of the Anti-kickback statute, as well as beneficiary inducements that would be in violation of the civil monetary penalties law. I think it's helpful, when talking about some of these things to, note sort of what is eligible, but also sort of what is not eligible. And so under the OIG Self-Disclosure Protocol, what is not eligible would be Stark-only conduct, errors or overpayments where there's no potential violation of the civil monetary penalties law, settlements that are less than $10,000 or $50,000 for the anti-kickback statute, or a situation where you're requesting an opinion as to whether or not there is a potential advisory, or a potential violation. And the reason why they have that is because the OIG has the separate OIG opinion process that is the proper avenue to go down if you are requesting an opinion as to whether or not there might be a potential violation. The other one I had mentioned was the CMS Stark Self-Referral Disclosure Protocol. And this was born out of the Affordable Care Act, Section 6409. The intent here was really to establish a process that would enable providers of services and suppliers to self-disclose actual or potential violations of the Physician Self-Referral Statute, or Stark Law, which we'll talk about here in a little bit. It was issued back in 2010, and it can't be used to determine whether CMS, or to determine from CMS whether or not a Stark violation had occurred, and I think that's just something to point out. And we'll talk a little bit more about the nuts and bolts of the self-referral disclosure protocol a little bit later as we go on. Just generally note, though, that if you, as you're working through one of these overpayment issues, again, this is something to take into consideration in terms of, factually, do you have a situation that might potentially trigger the self-referral disclosure protocol or the OIG self-disclosure protocol, or is it essentially just a simple overpayment issue for which you're going to proceed down the 60-day overpayment rule? Okay, so let's shift gears now that we've sort of laid some foundation and background to different self-disclosure reporting avenues and possibilities. Let's talk through just the reporting and the repayment sort of regulatory framework. So just generally speaking, you might have potential overpayment could be based on the violation of one of these substantive federal laws, which is the Stark Law or the Anti-kickback statute or the False Claims Act. And something just to point out, I sort of put a little comment there at the bottom, is these are obviously the federal laws that you need to take into account. You also want to make sure that you're checking with your particular state, because your state may also have a similar self-referral type ban or anti-kickback statute type ban or even False Claims Act type ban. So you want to just make sure that when you're working on these issues, you are consistent with both state and federal laws and making sure you identify any potential nuances. And again, that's another reason why you want to make sure that you do engage legal counsel as you work on these particular issues. But these are essentially the substantive laws that are potentially in violation. There's a couple others, the Civil Monetary Penalties Law, which I had mentioned earlier, and that authorizes different fines and penalties based on violations of these three laws. There's also the Exclusion Statute, which is another arsenal or a weapon within the government's arsenal to try and bring about a settlement. And so it's another potential penalty for which a healthcare provider could be facing for violations of one of these three laws. So let's talk through each of these just real briefly. So the Physician Self-Referral Ban, or the Stark Law, prohibits physicians from referring Medicare and Medicaid patients for what's known as designated health services to an entity that the physician or immediate family member has a financial relationship with, unless there's an exception that applies. A couple comments to note at the outset. When this particular law was first passed, it really was addressing some studies that made their way to Congress regarding physicians that had ownership relationships with entities that they were referring Medicare and Medicaid patients to. That has been expanded over the years to include other types of financial relationships, such as a compensation relationship. So that could mean that it would potentially a medical directorship or another professional services agreement between a physician and the recipient of referrals from that physician possibly could get triggered from the Stark Law. And so you just want to make sure that you are complying with one of the exceptions. And there's a number of different exceptions that are out there, some of which you may be familiar with, such as the non-monetary compensation exception that allows certain gifts and non-cash type items to be given to physicians on an annual basis up to a certain dollar limit. There are exceptions for rental of equipment and office space, professional services agreements. So you want to make sure that you are in compliance with those particular exceptions so that you get away from any potential violation of the Stark Law. In terms of penalties under Stark, denial of payment, refunds of amounts collected from improperly submitted claims. There are civil monetary penalties of up to $15,000 for each improper claim submitted. Up to $100,000 from circumvention schemes, which essentially means that you knew that you were violating the Stark Law, but you did it anyway. And then just also note that it includes both the provider that's providing the DHS services as well as the entity that's billing for the provider that's providing DHS services. The Anti-Kickback Statute is another federal law that we need to take into account, which prohibits the knowingly and willfully soliciting, offering, giving, or receiving remuneration in exchange for referrals for items or services covered by a federal health care program. Remuneration is just a fancy word for anything of value, and there are certain safe harbors that permit certain arrangements. So similar to what I mentioned on the Stark side, where there are exceptions, under the Anti-Kickback Statute, there are safe harbors, and there are certain conditions within those safe harbors. There's a number of safe harbors that are out there, some of which have some overlap with the Stark Law, but again, you want to make sure that you are in compliance with these safe harbors to get yourself away from any potential violation of the Anti-Kickback Statute. Also just pointing out that the Stark Law, when we're talking about that, that is primarily physicians that are triggered under that particular law, whereas the Anti-Kickback Statute could apply to anybody. You can't give, offer, receive, or solicit anything of value in order to get somebody to send a Medicare or Medicaid patient. So it doesn't have to be a situation where a physician is involved. Under the penalties for the Anti-Kickback Statute, I apologize, there's actually a typo there. It should be actually up to 10 years in prison. Criminal fines of up to $100,000 and civil penalties of up to $100,000. Exclusion from participation in federal health care programs is another potential penalty under the Anti-Kickback Statute. These recent increases, as well as the imprisonment time going up to 10 years, these were recent increases that came from the quote-unquote so-called Trump tax bill that was passed back in March, and that's the first time that there have been increases in this particular area for a number of years. So I just wanted to make mention that there have been recent changes to the fines and penalties under the Anti-Kickback Statute that you should be aware of. And then finally, the False Claims Act. It prohibits anybody from knowingly presenting a false or fraudulent claim seeking payment to a federal government program. This is an old law that came about back in the 1860s during the Civil War, as there were different contractors providing services and products to the Union Army that was fighting the Civil War. Similar to 2018, back in the 1860s, you're always going to have a number of individuals trying to game the system. And so there were situations where they were providing guns that weren't fit for, or guns that didn't actually shoot, food that was rancid, and horses that were not fit for battle, and things like that. And so that's what prompted Congress to pass this law. Now in 2018, it is applicable to us in healthcare because of our participation in federal government programs such as Medicare, Medicaid, and TRICARE. Something to point out with the False Claims Act is this is typically a situation where, from a penalty standpoint, you're sort of facing triple duty, because one of the most common types of False Claims Act violations is a underlying Stark or anti-kickback type of violation. So if you have violated one of those other two laws, you're going to be subject to the fines and penalties under those laws. And if those particular Stark and anti-kickback violations involve the referrals of federal health care program patients, and there are claims that are submitted to Medicare, Medicaid, or other federal health care programs, that's going to trigger potential False Claims Act liability. So another thing to keep in mind as you're working through these issues is, what is the patient population that is involved? Do you have patients that are insured under a federal health care program, and has your organization received payments from a federal health care program, or is it just commercial type patients? So that's just something else to keep in mind. Under the False Claims Act, potential penalties, civil penalty from $10,781 to $21,563. That's per false claim, which doesn't sound like a lot of money, but when you're talking about thousands and thousands of claims, and then the government can basically take whatever that number is times 3 under that second bullet point, and that's really where the potential fines and penalties can add up. And then also another potential penalty is you're facing exclusion from federal health care programs. Okay. So let's talk about reporting and returning overpayments, specifically to contractors. Up front, just note that since we've already sort of addressed the substantive laws that are governing overpayments, so what we're going to kind of do here is just shift gears and talk through kind of the regulatory guidance for actually reporting and returning some of these overpayments. And so with regards to the 60-day rule, just the first thing to follow is you're essentially going to be following your MAC refund guidelines for reporting and returning overpayments. But along with that, you're going to be following the 60-day overpayment rule and some of those guidelines. So it's sort of looking at both of those particular areas. So something you want to make sure you understand is getting your head and hands around what are the refund guidelines specifically for your particular MAC. And typically, factually, what we're going to have here is with this type of situation is it's going to be a simple overpayment. There's evidence that an error had occurred that had resulted in an overpayment or money to which you're not otherwise entitled to that was billed out to a federal health care program in error. Typically it might involve a routine reimbursement issue such as an incorrect code. There's no actual evidence of fraud or anything like that. So let's take a look a little bit further through the 60-day overpayment rule. Because as I said, this will also, as you're working through these issues, you're going to have to look at both the refund guidelines and the 60-day overpayment rule. So diving into that a little bit more in detail, again, this was born out of the Affordable Care Act. And typically, it is a person that has received an overpayment has to report and return the overpayment within either 60 days after the date on which the overpayment was identified, or the date any corresponding cost report is due, whichever is later. An overpayment is, excuse me, any Medicare or Medicaid funds that the person receives or retains to which the person, after applicable reconciliation, is not entitled to. So a couple things to point out sort of at the outset is that this is only applicable to Medicare Parts A and B. I do have it listed up there that an overpayment does include Medicaid funds, but just note that there's a separate rule for Medicare. Well, this does apply to Medicaid, I'm sorry. There is a separate rule for Medicare Parts C and D is what I meant to say. So this is applicable to Medicare Part A and Part B as well as Medicaid, and there's a separate rule for Medicare Parts C and D. So if you're a participating provider in those other two programs, there's a separate 60-day overpayment rule that's similar to this, but just note that what we're going to go over today is just the one related to Medicare Parts A and B. Typically, if you have received these particular types of funds that you're not otherwise entitled to, the interpretation is essentially that it's what's known as a reverse false claim, which is you discovered at some point that you were not entitled to this money, and rather than turn the money back in and refund it, you decided to keep it. And so that's why it's interpreted as a reverse false claim. So I just included the sites up there. You know, after the Affordable Care Act was passed, it had taken a number of years for the regulators to issue final regulations, and that came out back in 2016 that talked really about the nuts and bolts of reporting and returning the overpayments, which we're going to talk about here in a little bit. So the final rule requires that an actual overpayment has to exist. So a claim or cost report errors that don't result in overpayments are not going to be subject to the final rule. Something else to note is that the 60-day overpayment rule focuses on those overpayments that are initiated or discovered through the normal course of business within the organization, whether that's a routine or a specific audit or another review of internal processes or something like that. So any overpayment determinations or demands or other final actions that are going to be asserted by a MAC or a RAC or CMS or the OIG or any other federal agency, those have to follow those existing processes for responding to those types of determinations. So that's something to keep in mind, is what we're focusing on here are just the ones that you have internally self-identified and made the decision to report and return the overpayments. So let's kind of walk through sort of the nuts and bolts of the 60-day overpayment rule. When we're talking about the 60-day overpayment rule, timing is obviously going to be really critical, and it's tied into knowing sort of what is meant by the word identified when it comes to the overpayment. And so under the regulations, identified is when a person has or should have through the when a person has or should have through the exercise of reasonable diligence determined that the person has received an overpayment and quantified the amount of the overpayment. So notice sort of the highlighted words here, and that's kind of where things can kind of get tricky in making sure that you understand the time frames. And sort of, from a 30,000-foot view, the two sort of concepts to keep in mind here is really one, reasonable diligence, which is one of the words I've got underlined, and then also quantification. And then when does that 60-day overpayment rule, or when does the 60-day clock start to trigger? That's sort of what becomes crucial questions as you're working through this. So when the 60-day clock, when does it start to tick? It starts to tick when, through the exercise of reasonable due diligence, and that has been completed, if you've determined whether or not you have an overpayment. So there has been some interpretation within CMS that should be interpreted as no later than 6 months. Also it starts to tick if there's a failure to exercise reasonable diligence and it's on the day in which the person that received credible information of a potential overpayment. So some things to note here, obviously CMS saying or interpreting that 6 months is really your time frame for exercising that due diligence piece. And then also credible information. It's not really defined, but it includes information that supports a reasonable belief that an overpayment has been received. So what exactly does that mean? Just some possible examples of what would be interpreted as credible information. Audits, whether they were done internally or externally, but again, in terms of external, that has to be through a third party, not through the federal government or as part of a federal government investigation or audit. Could be through internal compliance plan reviews that maybe are part of the compliance department's annual work plan. Also could be hotline reports or direct reports to the compliance department about potential issues, maybe from a department manager or maybe somebody in the billing office. Exit interviews that might reveal facts that support the possibility of billing for things incorrectly that would result in an overpayment. Subpoenas would be possibly another source of credible information. CMS contractor audits, again, might be indicative of credible information, but just remember, we're keeping this in mind as something that's in the past that has identified there might be a potential overpayment issue. And then ineligible persons or somebody that's been excluded, that might be an example. If you find that out, that would be potentially an example of credible type information. So in terms of what is the look-back period, an overpayment must be reported and returned in accordance with this particular section of the regulations when the person has identified the overpayment and within 6 years of the date that the overpayment was received. So something also to note, that's obviously, what is your time frame for due diligence, but then also sort of how far back in time do you have to go? And there can be possibly some practical challenges to that, such as, potentially poor record-keeping issues or maybe resources from which to conduct an audit, that type of thing. So I think it's sort of helpful, last few slides, we've kind of thrown out some different numbers, different time frames involved with regards to different parts of these particular regulations. And so I think it's kind of helpful just to sort of distill down to what is a good sort of workable formula to use in sort of a shorthand form. And so I just put this slide up here, sort of follow the sixes, which is the first one is 6 months. So from the moment at which something has been potentially identified, you've got 6 months for which to conduct your reasonable due diligence. And then if after that 6 months or within that 6-month time frame, you have quantified that there is a overpayment issue, then you would have 60 days to report and return that particular overpayment. And then the look back period that you need to go is going to be 6 years from the date in which the overpayment was made. So I wanted to put this up here. Unfortunately, we don't have time to go through this particular case, but just something for further research if you'd like to look into. There is a case that came out a couple years ago, shortly after the final rule was issued, that talked about sort of when identified is. And in short, in this particular case, there was a provider that had erroneously submitted claims to Medicaid for payment, and it turned out to be a software error. Fortunately, what happened in this particular case is that the provider had failed to fully investigate and identify the overpayments until 2 years later, after the government had conducted their investigation. And so the court here had put an interpretation on the word identification to basically include situations where a person is put on notice that a certain claim may have been overpaid. And in this particular case, I believe that they had settled for about $3 million. So there's not a lot of case law out here around the interpretation of the word defined. So we've got this as well as the CMS regulations that have discussed sort of the time frame for when you identify a potential overpayment. Okay. So now we've talked through sort of the background to the 60-day overpayment rule, different possible avenues for reporting and returning overpayments if you've got something outside of the 60-day overpayment rule. What I want to do is sort of shift gears and kind of talk through some of the logistics for responding to one of these particular types of issues. And so I thought it'd be kind of helpful just to talk through just some practical application of working on one of these particular types of issues. So this is sort of if you think you might have a potential repayment obligation, where do you proceed from there? And so the first thing that you want to do is just make sure that, when you're conducting your internal review, that you're determining the scope of the issue that's at hand. And so you want to ask some questions such as, what particular items or services are involved that were billed, which departments, which potential staff are involved, what types of claims, what's the number of claims that are involved. I mentioned earlier about, making sure you look at, was this involving commercial patients as well as government payer patients or just government payer patients. If there are government payer patients, making sure you understand how many were impacted and involved. And so these are just some of the initial kind of scope questions that you want to make sure that you're running through and thinking about as you go forward in your investigation and your internal review. You obviously want to identify the objective along with your scope. It's obviously going to be figuring out, well, what the heck happened, but also more specifically just determining, is this a simple overpayment that needs to be corrected, or is there potential fraud that's involved? And that sort of gets back to my initial comments at the outside of our presentation today. Also thinking kind of about, well, what steps are going to be needed to try and correct this particular behavior from happening again, what sort of mitigation efforts are going to need to be put in place. That should also be part of identifying what your objectives are going to be, and as well as identifying any potential corrective action plan as part of those mitigation efforts. So that should all really roll up into identifying sort of what are going to be your objectives of the internal review. Also, you want to, obviously make sure that you are identifying sort of what the time period is that's involved. I'd alluded to this a little bit earlier, but specifically sort of, how far back in time are we going? Making sure that you've got a handle for tracking purposes of the 6-month time frame that you've got, the 60-day time frame that you've got, assuming that you do have a potential overpayment. These are things that you want to make sure that you've got identified and sort of mapped out in your head, as well as communicate with those that are going to be involved in assisting with your internal review. Also, you want to make sure that you identify what documents need to be collected and reviewed as part of your internal review. This is obviously going to be helpful in determining what had happened, how to resolve it, how to prevent it going forward, which is going to help you in meeting those objectives. The collection of documents, just from a practical standpoint, also can become critically important if you do have to report and disclose, because you may be required to include that information when you do your self-disclosure. And so I think that's an important point to mention if you are working with different stakeholders in your organization to assist in the internal review. And you may not have particular access to that information, then you need their help. You need their help to get that information. If you run into any resistance for turning that information over, that's, I think, an important point you want to make mention that you may need it because it may need to be included as part of the self-disclosure. And again, this is another area where I want to pause and make mention that it is important to make sure as you're working on these issues, no matter how simple or complex the issue may be, that you do have legal counsel involved to help guide you and assist you through this self-disclosure piece and making sure that you're turning over the proper documentation that needs to be turned over as part of your self-disclosure. The last thing, and I kind of alluded to this a little bit earlier, is sort of what resources and what parties need to be involved as part of your internal review. And sort of really everything on this slide, I think you can just sort of put under the headline of sort of internal review planning. But as I mentioned, there's possibly other stakeholders that are going to need to be involved, such as maybe members of different department directors, senior management, folks in accounting, folks in billing. If you use a third-party company for your billing, you may need to involve those folks as well as part of the investigation. And so this is really kind of part of the presentation where, I mentioned that, as you're working through these issues, it's not something you can do alone, nor should you do alone, and it really takes a village because of all the subject matter experts that really need to be involved to help you. And so you just want to make sure that you're leveraging those resources, as you're working on this resolution to this issue and getting you the right access to the right documents to help you resolve the particular issue. So really kind of as you're working on this, depending upon your organization, you may have sort of an ad hoc committee, maybe your subcommittee of your compliance committee that would need to assemble to kind of work through the investigation and resolution to this particular type of issue. But really compliance should be sort of driving the review, the internal review, and then sort of making assignments to those subject matter experts that need to be involved, who own certain pieces of information, and making sure that you're collaboratively working together to resolve the issue. Okay, so let's shift gears. Now we've talked through sort of conducting an internal review related to a potential overpayment issue. I wanted to talk through just some key decision points that you need to kind of keep in the back of your mind as you're conducting your internal review, and this would help kind of guide you in terms of, if you've got just a 60-day overpayment issue that you're working on, kind of how you're going to work through that issue. If you potentially have another type of overpayment issue where you need to report and self-disclose down one of the other avenues, such as the OIG Self-Disclosure Protocol or the Self-Referral Disclosure Protocol. These are some of those decision points that you need to kind of keep in mind in terms of how you're going to handle the review and sort of what are the pros and cons to reporting out under one of these different types of avenues if you're not using the 60-day overpayment rule, or if that's not applicable, excuse me. So the first thing is, from a key decision point standpoint, is whether or not to invoke the attorney-client privilege. Generally speaking, it can protect communications from discovery and litigation, but there's also just some restrictions around that privilege, such as, it has to be in the anticipation of potential litigation, and it's really only limited to those immediate folks that are involved in the issue. And so, from a communication standpoint, this is where it can become critically important to limit those folks that are involved in the communications. And this is another example where you want to make sure that you are involving legal counsel early on to help drive this process and help guide you through invoking attorney-client privilege if that is particularly applicable. Because they can help you in terms of identifying what documents need to be preserved. They can help you with putting a hold, communicating to maybe other folks in the organization that need to know what's going on and the fact that they need to preserve certain documents. They can help guide through sort of what types of notifications need to be involved. How do you want to help identify the scope of the review, which I'd kind of talked about a little bit earlier. So these are just some things to kind of keep in the back of your mind, as you're working through that. So with the attorney-client privilege in particular, it's going to protect the advice, but not necessarily the acts. So just keep that in mind. And it protects the communications, but just know that that can be lost if the information is then forwarded on to somebody else. So that's why you want to make sure that you are operating at the guidance of your legal counsel to help preserve that particular protection. So aside from the attorney-client privilege, obviously scope of the review is something you need to figure out, as well as the time period that's involved. What type of review are you going to do? Is it all claims? Are you going to do a probe review, a statistical sample, that type of thing? These are just, again, just some key decision points to keep in your mind, as you're working through investigating and resolving one of these particular types of issues. Another key decision point is going to be risk mitigation. So, how do you go about ceasing billing, until the issue is corrected? What communications need to happen? Who do you need to communicate to cease billing out on this particular issue until you're able to resolve that? And then, of course, making sure you close the loop on the back end once the issue has been resolved, and educating those people as to what the resolution was and what steps need to take place in order to prevent it from happening again in the future. you need to make sure that you, as part of this, how are you going to go about identifying the root cause? What resources are going to be available? This is where you might need to bring in your IT folks to help you in sorting through some of the data, gathering the data and then sorting through the data to help determine some of these root cause issues. Is this an isolated issue? Was it a systemic issue? How are you going to prevent it going forward? Is this a particular area that might be ripe for doing future auditing? If you are going to audit, how frequently do you want to do a follow-up audit? Do you want to do it once a month, once a quarter, once a year? Again, a lot of these answers are going to be fact-specific depending upon how large in scope the particular issue you have and how serious it is. And then also, what does re-education look like, and who does re-education need to be directed at going forward in order to prevent this from happening again in the future? So these are just some of your questions that you need to sort of identify and help answer as you work through these particular issues. Okay, so I wanted to sort of take a step back out now from the 60-day overpayment rule and a little bit more globally look at just the topic of self-disclosures and repayments and the different avenues that you have to report down, because there are some additional key decision points that can factor in depending upon the facts and circumstances that you have. So again, these are going to be situations where you may or may not necessarily have a simple overpayment type issue. So the first one obviously is, where are you going to self-disclose this? Is this something you're going to do a refund to your Medicare contractor through the 60-day overpayment rule? Is it something where you're going to report it through the OIG Self-Disclosure Protocol? Are you going to report it under the CMS Self-Referral Disclosure Protocol? Is this a state Medicaid issue only that is going to require reporting out to a state Medicaid agency, and what are those requirements? Or is it something that factually it makes sense just to do a direct referral to the Department of Justice? So just some kind of pros and cons. When we're talking about just refunding to the contractors essentially under the 60-day overpayment rule, these are, just generally speaking, going to be less costly. You're going to have administrative fees, legal fees that are going to be involved in resolving the issue. It's a less costly return on the overpayment. It's essentially a dollar to a dollar repayment formula. It's a much more simplified process. You essentially do your audit, define your scope, determine the amount of claims and the dollar amount that's involved, and then send a letter onto your MAC, or obviously make sure you go through the process that's dictated by your particular MAC for refunding overpayments. But just make sure you have that information together and then issue the overpayment back to the MAC in whatever form that they prefer. But it is a much more simplified process than these other avenues, such as the disclosure protocols. Does satisfy your obligation to report and return the overpayment. Again, the look-back period is going to be 6 years, and then it potentially would reduce your False Claims Act liability exposure. On the con side, there's no release in terms of potential liability under fraud and abuse laws, and you may still be subject to investigation from the government agency. So that's just something to kind of keep in the back of your mind. There's always at least some risk with that. With regard to the OIG Self-Disclosure Protocol, this is going to avoid a CIA or a corporate integrity agreement, an exclusion, presumably. And I say presumably because there's no real guarantee, but sort of history has shown that when you go down this road, the intent is to avoid entering into a CIA or exclusion penalties. Also has lower cost. It's a it's $1 to $1.50 type multiplier that's involved with the overpayment. It's a quicker resolution, relatively speaking, to the self-referral disclosure protocol, which I'll talk about here in a sec. But it's not likely to be as quick as just a simple refund to MAC for an overpayment issue. Also, a little bit more of a predictable process as opposed to something like a direct referral to the Department of Justice. So as you kind of work through this, and if you do submit something to the self-disclosure protocol, you get what's called acceptance into the self-disclosure protocol, and it potentially could avoid an ongoing investigation by the Department of Justice or other federal agencies. So that's something to keep in mind. And then the other sort of benefit to it is once you get accepted into the self-disclosure protocol, it does suspend or toll that 60-day overpayment rule. So that's just something to keep in the back of your mind. On the con side, there's no real guarantee that you're going to get accepted into the self-disclosure protocol. You can't use it for stark only type violations. That's what the self-referral disclosure protocol is for. The OIG can't release False Claims Act liability. They don't have the authority to do that. And so the issue could get referred over to the Department of Justice to investigate. So that's something also to keep in mind with regards to the OIG self-disclosure protocol. For the CMS self-referral disclosure protocol, some of the pros here, again, it stops the 60-day overpayment rule after you have submitted it to CMS. It does limit your False Claims Act liability exposure, but there's no authority to provide a release. CMS doesn't have that authority. And again, it's a little bit more of a predictable process as opposed to direct referral to the Department of Justice. On the con side, it has to, again, be just a stark-only type violation. There are limited releases. There's no release, for example, for potential False Claims Act liability or civil monetary penalties liability. The issue could get referred to the OIG or the DOJ to investigate further, so that's something to keep in mind. And there is a very long timeline for resolution. And this is one where they are backlogged for years and years and years on this. So that's something to keep in the back of your mind, that it's not going to be a quick resolution if you're disclosing through the STARK self-referral disclosure protocol. If you have something that just involves state agencies such as Medicaid claims, on the pro side, you can get released from the state False Claims Act claims, but on the con side, it's only applicable to state agencies, and every state's going to vary in their rules and applications, as well as statute of limitations can vary depending upon your state rules. So that's something to kind of keep in mind when you've got state agency type overpayment issues. Now, I kind of mentioned this a little bit earlier, but the DOJ self-referral, this is a possible avenue to go down, and I just mentioned that as possible with sort of an underline and asterisk. This is where I would absolutely say you need the advice and counsel of legal counsel before you would go down this particular avenue. But it could be advantageous to do this if there's an existing positive business relationship with the Department of Justice and the facts really indicate there's a likely False Claims Act violation, and it might just be best to go ahead and just self-report that matter to the Department of Justice. They do have the ability to release False Claims Act liability and exclusion. So these are just sort of some of the pros. But again, you want to make sure that you've got the advice of legal counsel before you proceed down this avenue. But I mention it as it is a possibility, and it's another avenue for self-disclosing and overpayment. On the con side, just be aware that you are likely going to be subject to a DOJ investigation, which is going to be much more extensive than some of the other federal agencies and the other processes that are in place. Obviously, it's going to be a much less predictable outcome as opposed to the others. You have DOJ investigators and attorneys that are going to vary in their interpretation of law from one to the other, so it creates a less predictable process or potential outcome. And just keep in mind that they can't release you from some administrative authorities, fines and penalties. So, for example, there's no release for a corporate integrity agreement. So those are just some of the kind of key things to keep in mind as it relates to some of these other types of reporting and avenues that you could proceed down, and that's sort of something you want to keep in the back of your mind as you're working through this issue, depending upon factually what type of issue do you have? Is it just a simple overpayment, or is it something that might be indicative of potential fraud? So I'd like to kind of conclude by just talking through some of the logistics for reporting and returning overpayments. And this is sort of assuming that you've done your internal review, you've concluded that there is an overpayment, and now the next thing you need to do is move forward in disclosing that particular overpayment. So with regards to a simple contractor refund, you're going to be following whatever your MAC guidelines are for refunds, and you're going to follow the 60-day overpayment rule for those obligations and timelines. So it's pretty straightforward. With regards to the OIG Self-Disclosure Protocol, there are a little bit more stringent requirements that are in place. You have to submit it in writing. There is the OIG Self-Disclosure website, which I've included the link there. And there is what's known as the April 2013 protocol, and I'll show you an example of what that looks like here in just a sec. But so just a couple of things to kind of keep in the back of your mind is that if you're disclosing, the disclosing party is expected to conduct an internal investigation and report its findings to the OIG as part of its submission. So that's something that you need to make sure is done before you get to the point of actually submitting through the protocol. And then just also note that if the disclosing party is, if you're not able to complete that internal investigation before sending in your submission, then you have to certify that the submission will be complete with the internal investigation within 90 days of your initial submission. So that's just something to kind of keep in the back of your mind. Here's a screenshot of what the OIG Self-Disclosure Protocol is that came out a few years ago. You can do just a general internet search and it should pull it up. Just a couple things additionally to point out in terms of requirements. So you have to include some statements with regards to the conduct that had occurred, which laws that you think have been violated, and why. You have to include an estimation of the damages as well as statements regarding your corrective action. And so this, again, is another reason why you want to make sure, because of some of these disclosures and statements that are made, that you have the advice and counsel of an attorney helping guide you through the finalized language that's going to be submitted as part of the OIG Self-Disclosure Protocol. I think some common areas where folks can get tripped up is, not identifying the potential laws that are violated, not quantifying those damages, conduct maybe that only involves Stark violations, which should go through the Stark Self-Referral Disclosure Protocol, or just a general overall lack of cooperation with the OIG. I think that's where folks can fall down with regards to reporting and returning an overpayment through the OIG SDP. So shifting gears to the CMS Self-Referral Disclosure Protocol, if this is the avenue that you're going down, they recently last year had issued a voluntary self-referral disclosure protocol. And again, if you do just a general internet search, you can find it. There is an electronic document that you need to use if you're going to include this submission, and there are some instructions that are included if this is the avenue you're going to go down. With regards to reporting and returning state agencies, again, this is Medicaid claims only. You'd have to check with your state agency guidelines and follow whatever those guidelines are for how you need to actually report and return those overpayments. So just a couple things to end with, just by way of takeaways, is, obviously the very, very first step, before you decide to conduct your internal review and identify your scope, is to communicate with your billing folks to cease billing, while you further investigate. That really absolutely should be step one once you become aware of the potential issue. Working with legal counsel, as I have mentioned several times today, will help you through this process to ensure that you are disclosing the right amount of information, you are properly disclosing that information, and they can assist with how to protect some of the communications and how best to work through the actual investigation and overpayment issue. You need to make sure that you identify the regulations that are going to apply, what type of reporting you're going to do. Is this going to be a simple overpayment issue for which you would follow the 60-day overpayment rule, or is this something that you're going to self-disclose through one of the protocols? And then you just want to make sure that you're sort of efficiently and thoroughly working through that approach, which is to say that you want to make sure that you are anticipating potential questions that may come up from the government as you make your submission, and being proactive in the information that you're providing to them that might raise potential questions. Rather than have them ask the questions of you, you want to make sure you provide the answers to those anticipated questions. And again, that's another area where an attorney can help you with that. And then just overall, make sure you cooperate. Again, that's an area where a lot of folks can fall down, is not cooperating with the government once they have conducted, or once you've reported and they are conducting their investigation. So I hope that information was helpful. I know we've got some other webinars coming up later this year, and so thank you very much for joining us today, and I'd be happy to take any questions that you may have.
Yeah, thank you, Jay, for the presentation. Thank you all the participating for cooperating with us. Now it's time to begin Q&A session. Anybody having a question, you can just share it through chat window. Also, I'm unmuting all the attendee lines. Anybody having a question, you can just ask the question over the phone. Any question? Yeah, Jay, we are having one question, so I have just forwarded to you.
Oh, okay. Yeah, question came in terms of when will my overpayment take effect? So this is going to be another area where it's going to be difficult for me to answer that. It, you know, if you're refunding it through the max, it's just going to be dependent upon their particular refund guidelines. So that would be a question that you'd want to make sure you direct towards your MAC. Or they may have resources on their website too. Another question came in, are there any charges for making an overpayment? This essentially is going to get interpreted with regards to the potential fines and penalties. So as I mentioned earlier, when you've got just a simple refund type issue, it's essentially a dollar for a dollar. So there's no real charge for making the overpayment. You just basically have taken whatever money that is and then refunding that back to the MAC dollar for dollar. So there's no additional fines or penalties that are involved. There are potential multipliers that can get involved when you refund through the OIG Self-Disclosure Protocol, for example, which is 1.5 multiplier.
One more question. So,
yeah, another question came in about the look-back period. Again, it's going to be 6 years from the date that the overpayment was made that you would go back. And then in terms of finding out how much is in your overpayment reserve, that again is a question that you would need to direct with regards to your MAC. Another question came in about who's responsible for identifying and refunding the overpayments. With regards to who's responsible for that, it's going to essentially be, again, an internal responsibility. So all these areas where we've been talking about today, they're not going to be something that is going to be the subject of a federal government agency audit or investigation. So these are things that are going to be discovered within the organization. In terms of exactly who, that's going to depend upon your particular organization. Again, just remember that the source has to be from credible information, and that could come from a number of different areas. It could be that maybe it was something that was discovered in an internal audit or compliance review. Maybe somebody reported it to the hotline. Or maybe just a random employee happened to be going through an exit interview, and maybe they were in the billing department and they provided some information with regards to an overpayment issue that needed to be investigated. So it could come from a number of different areas in terms of the responsibility for identifying it. Really, I would say the responsibility for investigating it, again, should be within compliance. They should be the ones that are driving that particular process, along with the assistance of different subject matter experts through the semblance of a investigation subcommittee or something like that that involves department directors that are involved. It involves billing staff that are involved, or directors, folks in accounting, or other senior management folks, legal counsel as well. So again, some of that just depends upon your particular organization and the resources that you have available.
Yeah, it seems there is no questions at this moment. However, you can still send your questions to our email ID at support@compliancekey.us. With this, we will end the session. We appreciate your time and believe the session was informative and up to your expectation. We look forward to see you in your next event. Soon you will be receiving the certificate of attendance and a feedback form. Kindly send your feedback. Your feedback is important for us. Once again, thank you so much for participating in this webinar, and I wish you a pleasant day ahead. Thank you, Jay, for the presentation.
Thank you.
Bye.
Bye.